Now the recording is on. Welcome, everybody. A very warm welcome to this online expert roundtable on the famous ECJ judgment Costa versus Enel. My name is Jutta Schulze-Holmin. I'm a director at the EP Research Service, and it's with great pleasure that I introduce our event today. As you will recall, we celebrated last year the 60th anniversary of the Costa Enel case. And of course, it proclaimed the principle of primacy of EU law, so a milestone in the development of EU law. We will today shed light at another aspect of this case. And we have therefore invited Professor Amedeo Arena. Welcome. And Professor Arena will present his research into the role of individuals in moving forward EU law, and specifically here, the role of an Italian lawyer and professor, Stendardi, namely the attorney behind the case. Of course, he was an EU enthusiast, and he wanted to give the ECJ to pronounce itself precisely on the issue of primacy. Professor Arena's presentation will be followed by expert comments from Professor Sacha Garben. Welcome also to you. You're a permanent professor at the College of Europe in Bruges, and you will kindly take us through the subsequent reception of this famous case, the settling of the primacy doctrine, and also the contestation by some national constitutional courts. Our third guest speaker is María José Martínez Iglesias, our former colleague, very well known, well, first of all, for many years as the head of the Legal Affairs Committee Secretariat, and then as director in the legal service of the European Parliament. María José, you finished your career as Director General of DG SAFE, Security and Safety. However, today you will not talk about security, although we just had a street shooting here in Brussels. I shall inform the audience, but you will rather share your experience of your work within the Secretariat of the European Convention. And of course, notably the proposal of codifying the principle of primacy in the European Constitution. Most of our expert audience, the larger part of the audience, will know that this failed, but it led to a declaration attached to the Lisbon Treaty. So we're very curious to hear from you as well. And you all have very impressive biographies, and I allow myself to refer to those which everyone should have received. The series of presentations will be concluded by my dear colleague, there he is, Rafał Mańko, and Rafał will present EPRS briefings on selected foundational cases of EU law. Rafał is not only a policy analyst within the Citizens Policies unit within EPRS, but he's also a renowned academic. He holds a PhD in law from the Amsterdam University, and he has received an habilitation in law from, it's my favorite Polish city, Wrocław University. So I hand over to Micaela Del Monte, my dear colleague and head of the Citizens Policies unit, who will moderate the event. And I myself curious to hear the expert knowledge of this esteemed circle. Thank you very much, and over to you, Mika.
Thank you, Jutta, and good morning, everyone. Sorry for this little change. We are experiencing some problem in the setting, but will be solved soon. First of all, before giving the floor to the distinguished panelists, just let me remind the audience that they can post anytime their question on the chat functions, so we can read them in the end. I'm very pleased to be the moderator of this panel. Those who have studied EU law are probably, or should be, familiar with the Costa Enel ruling. We are less familiar, at least myself, with the story behind the ruling, as Jutta said, and with the people that brought the case and worked on the case. So without further ado, I would like to give the floor to Amedeo. Thank you.
Thank you very much, and well, thanks a lot to the European Parliamentary Research Service for setting up this webinar on Costa versus Enel, which is a true classic of EU law. And as every classic, according to Mark Twain's definition, it is something everybody praises, but nobody reads, or to be specific to the legal context, that many people cite, but few actually read in full. And therefore, as a sort of introduction to this webinar, I'd like to go back to this classic and examine a little bit its context and its implication for the role of individuals. So the story really starts, at least in my opinion, in October 1962, when American spy planes flying over Cuba revealed the number of nuclear missile sites ready to strike main US cities on the East Coast. What prompted such a bold move? But as a matter of fact, Khrushchev was just trying to match the nuclear deterrence that the Americans had gained thanks to their nuclear missile sites in Europe. Also in Italy, in Gioia del Colle, there were a number of US Jupiter missile installations that had main Soviet cities within range. And this had been possible thanks to the pro-American foreign policy of the centrist government led by Amintore Fanfani, who was on pretty good terms with American President JFK, as we can see here from this picture taken in the Oval Office. However, the electoral support for Fanfani's government, the Christian Democrats, was declining at the end of the 50s. Therefore, in order to stay in power and to continue their pro-American foreign policy, the Christian Democrats had to strike an alliance with an unlikely bedfellow, the Italian Socialist Party, which gave its external support to the Christian Democrat-led government, but in exchange asked for something unprecedented in Italian economic history, the nationalization of electricity production and distribution. Now, at the time, electricity was a very profitable business in the hands of a myriad of small companies that were controlled by oligopolists known as the electric barons. And the nationalization of electricity was strongly opposed by right and center-right parties, including the monarchists and the liberals. But despite their fierce opposition in Parliament, by the end of 1962, the statute establishing the electricity monopoly in the hands of a state-controlled monopolist, Enel, was published in the official journal, and the stock market crashed. So the shareholders of the nationalized companies, they organized rallies, they gathered in theaters to oppose nationalization, and one of the most vocal of them was Gian Galeazzo Stendardi. He was a scholar of constitutional law and also a lawyer. He was involved in some of the earliest cases decided by the Italian Constitutional Court. He was also an expert in community law, and he wrote the very first monograph entirely devoted to the relationship between community law and Italian law, where he, of course, took the view that community law took precedence over Italian law. And politically, he was a monarchist, so he wanted to fight the nationalization statute, which he thought was incompatible both with the Italian constitution and the treaty establishing the European Economic Community. However, he could not challenge the nationalization statute directly. He could only do that in the context of a lawsuit involving that statute. And here is where Flaminio Costa came in. He was also a lawyer from Milan, same as Stendardi. He was also a monarchist sympathizer, and he was a user and a shareholder of Edison Volta, one of the nationalized companies. So when he received his first electricity bill from Enel rather than Edison Volta, he refused to pay it, arguing that the nationalization statute and all its implementing acts were contrary both to the Italian constitution and the EEC treaty. Therefore, Stendardi and Costa asked the Justice of Peace of Milan, in the context of the lawsuit that ensued from failing to pay the first bill, to refer the matter to the Court of Justice in Luxembourg and to the Italian Constitutional Court in Rome, However, only the latter request was granted. And in its judgment of February 1964, the Italian Constitutional Court dismissed all constitutionality challenges brought against the nationalization statute. And as regards the alleged violation of the EEC Treaty, the Italian Constitutional Court found that community law in the Italian legal order had the same rank as that of the statute that had ratified the EEC Treaty. Therefore, in case of conflict with the subsequent statute, such as the statute nationalizing electricity and establishing Enel, well, the latter statute would prevail. This was the chronicle of a defeat foretold, because the Italian Constitutional Court essentially sided with the dualist conception of the relationship between international law and national law, which was largely prevalent in academia at the time. Besides, undoing the nationalization would have been extremely costly from an economic point of view, as well as destabilizing from a political point of view. This was indeed the height of Cold War, after all. However, Stendardi had another ace up his sleeve as soon as he learned that the first Giudice Conciliatore, the first small claims court of Milan, was not willing to refer the case to the Court of Justice in Luxembourg. He, on behalf of Costa, instituted another set of proceedings before the small claims of Milan, challenging the next electricity bill that Costa had received. And this time, the judge was Vittorio Emanuele Fabbri, also a lawyer, also from Milan, also a monarchist sympathizer. And in its order of 16th of January 1964, Vittorio Emanuele Fabbri made the very first preliminary reference by an Italian court to the Court of Justice, asking essentially whether the Enel statute was in line with 4 provisions of the EEC Treaty. Now we can read here some excerpt from Stendardi's observation to the Court of Justice. Essentially took the view that the nationalization statute conflicted with Article 102 EEC that required the member states to notify the Commission in advance of statutes that could distort competition. Also, he claimed that Italy had failed to notify the statute as required by Article 93, provision on state aids, and also that the nationalization statute entailed the violation of the right of establishment, because nationalization, as the name itself suggests, is to reserve certain economic activity to nationals, and therefore is inherently discriminatory against people from other member states. And finally, Stendardi claimed that the statute was contrary to Article 37 concerning commercial monopolies. And he also went all in with some, let's say, political remarks. So he argued that the nationalization statute was a measure worthy of the Middle Ages, where tyrants sought to tear Europe in pieces, whereas the scope of the EEC Treaty was the unification of Europe. He also claimed that the nationalization statute had as its objective the transition of the Italian economy to the application of the doctrines of Marx, Engels, and Lenin, which, of course, was something incompatible with the goals of the common market and the EEC Treaty. Most importantly, he pointed out that should the ECJ find that the nationalization statute was indeed in conflict with the EEC Treaty, that preliminary ruling might have prompted other Italian courts, such as the referring court, to set aside, to disapply the Italian statute of nationalization in order to ensure the prevalence of the EEC Treaty. So Italy was represented by Riccardo Monaco, a very famous professor of international law, and Luciano Tracanna, and the Italian government argued that the order for reference was inadmissible. After all, the Italian Constitutional Court had already clarified that in case of conflict between an Italian statute and the EEC Treaty, well, the Italian courts had to apply the later statute. Therefore, there was no need for the ECJ to interpret the 4 provisions on the internal market, which were referred to in the order for reference. The European Commission was instead represented by Giuseppe Marchesini, who took the opportunity provided by the plea of admissibility raised by the Italian government to introduce, in the context of the proceedings before the Court of Justice, the topic of the consequences of the judgment of the Italian Constitutional Court, which, according to Marchesini and Michel Godet, posed an existential threat to the community because it created a permanent imbalance in the obligations of the member states that recognize primacy, such as the Netherlands, for example, and member states such as Italy that had dualist tradition and that were unwilling to recognize the primacy of community law. Advocate General Lagrange, in his opinion, he took the view that the rank of community law in the domestic legal orders was a constitutional problem, but still he urged the Court of Justice to rule on this case, as its ruling could indeed affect national judicial proceedings. And on that very famous day, the 15th of July, 1964, the Court of Justice found that the plea of inadmissibility was not well-founded. So the court ruled on the case, and in particular it ruled that Article 177 on the preliminary ruling procedure had to be applied regardless of any domestic law, because the treaty had entailed a permanent limitation of the sovereign rights of the member states against which a subsequent unilateral act could not prevail. So it was a very strong version of the principle of primacy that had been affirmed, but the court was instead quite different when it came to internal market policy. After all, this was the first time the court interpreted Articles 102, 93, 53, and 37 EEC, and the court gave a rather narrow interpretation. For example, the court ruled that Article 102 and 93 had no direct effect, and therefore, especially Article 102 became, shortly after, a dead letter, because individuals cannot really rely on it. The court found that Article 53 and 37 had direct effect, but as to the right of establishment in Article 53, the court adopted a very narrow interpretation and ruled that it was only about discriminatory measures, and that, the court impliedly noted that the nationalization statute was not discriminatory because citizens of Italy and of other member states would be equally prohibited from engaging in the nationalized activities. So this mattered because at the end of the day, the Court of Justice did not really declare that the nationalization statute was in contrast with the EC treaty. Rather, it left to the referring court to ascertain whether that was the case of Article 37. So the judgment of the ECJ did not really trigger strong political reactions at the national level, and it also escaped the attention of the general public for an incredible historical coincidence, because when the judgment came out, the Italian print workers were on strike, and when publications resumed after 4 days, this judgment was not reported in the generalist newspapers. So when the case came back to the Small Claims Court of Milan, Judge Fabbri found that the Enel statute conflicted not with one but two provisions of the EEC treaty and decided to set it aside. However, it's interesting to look how this judgment was reported in generalist newspapers. La legge sull'Enel sarebbe illegittima. It would seem that the Enel statute is unlawful, already foreshadowing the possibility that this judgment could be indeed appealed. And that was the case, because the judgment was appealed before the Italian Supreme Court, which ruled on the case in 1970, and the Italian Supreme Court took the decision that Costa really had no legal interest to bring proceedings, and that this case was only about the constitutionality of the Enel statute, and therefore it quashed the ruling of the Small Claims Court of Milan of 1966. So let's have a look at this ruling from a long-term perspective. This ruling, as many other landmark rulings, entails a trade-off between a strong version of primacy and a relatively mild version of internal market policy. However, this ruling enabled individuals to become enforcers of community law. So combining primacy and direct effect, individuals indeed were actors in the establishment of the internal market, and therefore, in a long-term perspective, this judgment contributed to the establishment of the internal market, even if in the shorter perspective, it was a sort of a retrenchment or relatively conservative version. Thank you very much, and I look forward to listening to the other panelists. Thank you.
Thank you, Amedeo. It was fascinating. You probably refer in one of the articles you wrote that it was a small claim for an unpaid electricity bill, in this case, that it would be equivalent to 20 euros nowadays, that brought such a landmark case and many efforts after many years also. And that also we will discuss later on avec María José whether or not this ruling remain uncontested or challenges over the year. But now I would like to pass the floor to Sacha. She would like not only to comment but also build upon her work on constitutionalism, on EU law, but also on the primacy of the principle of primacy. Thank you.
Thank you very much, Mica. And thank you, Amedeo, for this very vivid presentation. I think those must have been the best PowerPoint slides I have ever seen in my life. And they are amazing to look at, but also with the granular detail that they provide into the coming into being of this landmark judgment. It's also interesting, I think, precisely to see how things that become almost abstract, ethereal legal concepts completely disconnected from the very real realities and idiosyncrasies of factual circumstances and human personalities in which they arise, and you tie us back to all those very specific circumstances, which is really great. I also liked, by the way, this what you said towards the end of the presentation, which of course applies, I think, more generally to the court's methodology, that there tends to be a kind of strategy, perhaps sometimes, in letting the parties think that they won somehow, but what they won was just the battle, and they lost, in a way, the war. Well, not maybe the parties here, but there is a trade-off, indeed, as you say, sometimes between very important landmark principles that are pronounced that are going to restructure the entire legal order, and the actual effect in a particular case when something is referred back to the national judge, and the outcome may actually not coincide so much with that very big principle as it is pronounced. So that was all very wonderful. I myself have been working on some of these themes now for quite some time, and also in the context of a book I'm currently finalizing on conferral competence and the constitutionalization of EU law. So obviously Costa is important in that respect, and one of the things that I think I would like to bring to this discussion first of all is how unsettled, in a way, all of this still is, even after 60 years. Van Gent and Costa, in a way, on both, the dust has not really settled, I think. So we don't only see that in, for instance, this very seminar, your work on retracing some of the roots, but just in the fact that these doctrines continue to be discussed and debated. This is perhaps always the case with these very landmark rulings that give meaning and texture to a legal system, and they have to be constantly revisited. Perhaps it is also because the court itself seems to sometimes nuance, sometimes revise, sometimes change a little bit what these doctrines exactly entail and require of national courts in particular circumstances, even conceptually what the interrelation is between, for instance, primacy and direct effect and the autonomous legal order. Do primacy and direct effect follow from the autonomous legal order, or is the legal order autonomous because of the special features of primacy and direct effect, for instance? Or is primacy supposed to be supremacy, in that it means that there is a complete and all-encompassing superiority of all of EU law over the national constitutions? Or is primacy about precedence, where it is a conflict rule that in a particular situation and within the scope of the conferred competences of the European Union, the EU law takes precedence over the conflicting national law, what would be a much more narrow approach, of course. And on all of this, scholars continue to build careers, right? We have to have something that keeps us off the street. The unsettled nature of all of this is, of course, also given additional emotion by the contestation that we have seen of mostly the supremacy manifestation or interpretation of primacy. And this is something that we can trace all the way back. And in some ways, I think, apart from maybe the Netherlands, there has not been a single constitutional order that has completely accepted the force of community EU law on its own terms in the domestic legal order. They have always found the basis in the national constitution. So for that matter, it didn't actually make a difference if it was a dualist or a monist system. Ultimately, it was the national constitution that determined monist or dualist, and therefore the particular relationship with EU law. But EU law would say, indeed, no, I am going to dictate all of this on my own terms, which was something the national constitutional and supreme courts and orders have generally never really accepted. But because in most, if not all cases, they applied the precedents of EU law, there wasn't really a big problem, right? There were some obviously very famous standoffs in the course of European integration, with the Maastricht Urteil of the German Constitutional Court being a tentpole in that regard. But it is, of course, with the contestation that we have seen in the past couple of years, where several apex national courts, so to say, have disapplied directly, so in a direct confrontation with the Court of Justice, the court's rulings, that all of this has injected a great deal of emotion further into the interesting question of supremacy, primacy, and the constitutional or not nature of the European Union. Ultimately, for me, I feel that what explains this enduring fascination with this question, and also indeed what is behind some of this contestation, is that I understand now Van Gent and Costa more as constitutional overtures, propositions by the Court of Justice. They hold a federal promise. And today, that federal promise has not yet been completely fulfilled. And so this federal promise is still unsettled, and it has that unsettling, increasingly unsettling effect of an unfulfilled promise somehow. So for me, maybe it sounds a little bit lyrical, but this is a way of approaching this. And what I mean by that federal promise and its unsettlement is, in very broad strokes, you know, there is this first period, this foundational period, the high time of constitutionalization of EU law, where these foundational doctrines are laid down, and they expound a federal vision of community authority and community law. We can go into this in the discussion, but so this is something that my analysis, I think, clearly shows in the book I'm working on, all the doctrines of the court and the way the court understands community authority, are derived from U.S. federalism, from the approaches of the U.S. Supreme Court, of the approach of the Federalists, James Madison and Hamilton, and the Federalist Papers, etc. With one difference. In the U.S. context, there is a democratic source for these federal powers, for the supremacy of federal law, which is laid down in the Constitution explicitly, but more importantly, that Constitution has been adopted by and in the name of the people. The court, of course, cannot change the fact in this time that the setup of the community, the way it was adopted on the basis of a treaty, as well as how it operates with no role for a parliament at that point in time, is confederal in nature. And so we have a conundrum there, that we have this confederal setup, but federal force authority. And the court wants to make good on this, I think, in this first foundational phase. And this is why it launches in these inspiring judgments, Le Ver, Chernobyl, and my personal favorite, titanium dioxide, which comes almost close to something like European parliamentary sovereignty in the way it empowers the European Parliament. I think, and if you read Mancini's work, for instance, and Pescatore, very much because it realizes there is a conundrum between this and a democratic deficit between the confederal functioning and the federal force of its authority in the community. Would it not have been nice if then they had listened to the Parliament's Spinelli draft, right? If a European constitution had indeed been adopted, which clearly provided supremacy, right? Which was maybe not to be adopted by the people, but in the name of the people, which overcame the principle of conferred powers. It established powers in the name of the peoples of Europe. And of course, it would have created a very democratic machinery for taking decisions. Member states wouldn't have it. They, with Maastricht, broke the federal promise. But they didn't do so explicitly because maybe member states are happy to be in a government of governments, right? Not government of people, by people, for people, but government of governments, for governments, by governments, of governments, right? So they reinsert the confederal, but condone partially the supranational. But they insert the community in this non-constitutionalized context of two pillars, where there is no direct effect, where there's no problem. Costa, Enel, and Van Gent don't apply in the second and third pillar, right? And they don't explicitly codify primacy and direct effect for the community pillar neither. That would be difficult for supremacy to do anyway, because of everything I've been saying. You would have to adopt a constitution, I think, to codify supremacy. But precedents, then, at least they could have codified. They also didn't do that. So then, I know I'm going too long, so I'll be very short on what follows. This decade post Maastricht, to me, is such a curiosity, because what we see then is that from this period in which we see this reassertion of conferral by the member states, they put it in the treaty, that's the way they structured the treaty, and we see the Maastricht Urteil by the German Constitutional Court, and we see the Court of Justice sort of responding with a couple of rulings, like Bangladesh, where suddenly it's no longer so concerned with the powers and prerogatives of the European Parliament, because the member states should be able to do what they want to do, take off the hat of being the council or not. We see KEK, we see tobacco advertisements, which is the opposite of titanium dioxide. So we see the court retreating. And what do we then see? Curiously, towards the end there of that decade, Joschka Fischer puts on the table, from confederation to federation, the constitutional option once again, in the face of the popular contestation that they were feeling from citizens that did not abide by this undemocratic construct of a government of governments that had come about post-Maastricht. Now, to be very honest, those citizens also did not seem to be all that much explicitly in favor of a European federation either. But I guess at that point in time, a little window of opportunity somehow opened, and we could have overcome control, and we could have given in on the court's promise. You know, we could have fulfilled that promise of Van Gent and Costa with a European constitution and with a supremacy clause. All of that failed because of a half-hearted attempt with the treaty establishing a constitution for Europe, which itself did not know if it was a constitution or a treaty. It couldn't tell any of the citizens if it was a treaty or a constitution. It had the primacy clause, yes, but I can tell you, being a Dutch citizen, in the discussions on the referendum, it was said this primacy clause doesn't actually mean anything, doesn't actually change anything. This does not mean it is an actual supremacy clause. Your national constitution remains in force. And that is in the Netherlands, the only country where, you know, supposedly this was not controversial at all. Anyway, we know what happened with the treaty establishing a constitution. It didn't establish a constitution. It didn't amount into a valid treaty, and it failed. And it is a failed constitutional moment, because at that point in time, what we could have done is genuinely ask the citizens, the peoples of Europe, in what kind of political system they want to live. And do they want a federation or not? Or what alternative? Let's have a debate. Let's mobilize, you know, the people on this question. The parliament had asked for it a second time, had created a second draft constitution in 1994, which again the member states sort of cast aside, even as they were now considering a potential constitutional option. So where does that leave us today with Lisbon, which very explicitly is not a constitution, which took out the primacy clause, put it in a non-binding declaration, upgraded its content, arguably, by explicitly referring to the case law of the Court of Justice, but downgraded its formal status by putting it in a non-binding declaration. In any event, it's a treaty, it's not a constitution, and there is no popular sovereignty that supports or justifies any supremacy derived from this in any event. So what should we do? Well, I think I agree with the Parliament that, you know, in this resolution said we need to put primacy in primary law. I mean, we need to have a decision on this at the primary law level. However, and so I don't know what the different views on this are in the Parliament or elsewhere, but in my view, as I've been saying, this is tied together with that constitutional question. And so primacy in a treaty, I don't think can meaningfully codify supremacy. To have supremacy, to have what the court promised us in Costa, we need a constitution. And I know it's not very sort of en vogue to say it. I don't care, to be honest. I don't intend to be en vogue. I think that a serious Democrat needs to consider that ultimately the source of authority needs to be tied to the people, not just individuals taking cases. I'm sorry, Amedeo, you know, the people, citizens, the peoples in a composite fashion, if you like in Switzerland, you can totally do that. But it needs a democratic foundation. And so that is, I think, where we are now. And that means we have quite a long way to go to actually do what Costa promised us. Thank you.
Thank you, Sacha. I must say that your intervention was equally fascinating, and I took note of a number of questions that maybe we can develop later on. I will have, surely María José can talk about some of them, because she was, if I understood correctly, in 4 ECG for the revision of the treaty. So probably those elements were also discussed. But please, María José, the floor is yours.
Thank you very much. And thank you to the EPRS to organize this debate. And really, I have enjoyed really a lot with your article, Amedeo. So it's like, I mean, a legal drama show. You have transformed this boring, European law landmark in a legal drama show, I will say. And your intervention, Sacha, stimulant as usual, is, I'm afraid that I'm coming now as the practitioner I am, so with a dose of pragmatism. I'm sorry for that, I apologize. And so I come back to then. So, as I said, for the practitioner I am, the question that appears for me as relevant after 60 years of this decision of the court, I think the relevant question is, does it work in practice? Is the primacy of union law respected by member states, by the national judiciary? It seems to me the answer is an unambiguous yes. It's a positive answer, but not deprived of nuances, in particularly when we look at some pronouncements of some constitutional courts, as you mentioned before, Sacha. And that introduces in the picture this position of some constitutional courts, some perplexities, or probably, but it's more problematic than perplexity, is some degree on uncertainty. The second question that comes to my mind is this one that has been already evoked. A constitutionalization of the principle in the treaties is really necessary? In this sense, an overview of the Precedent of Declaration 17 would be useful. Those precedents in the European Convention bring a little bit into light the connection between the principle of primacy and the problematic of distribution and exercise of powers, as you perfectly identify, I think. But coming back to this pragmatism, and then so the principle of primacy, if we come back to origins, is not particular to the legal order of the Union. It's a materialization of the classical principle of treaty law, pacta sunt servanda. But what makes the difference and European law are three elements, in my opinion. It made a difference, and a big difference. So the pacta sunt servanda principle applies also to legal acts that can be adopted by a majority vote, so that oblige a state against its will, which is the big difference. The second is that the efficiency of the coercion mechanism provided for in our treaties, the infringement procedure that can lead to an action before the court, and even to a subsequent financial penalty. And the third element is that, unlike other treaties, the signing of the treaties, in our case, implies full acceptance of the jurisdiction of the Court of Justice. I know that in the context of the constitutionalization, etc., that you were evoking before, this is really basic, exit ground. But in practice, this principle of primacy in itself is, in my opinion, accepted and respected by national political entities or the national judiciary. Among other things, thanks to the proper functioning of the preliminary ruling procedure, which has fostered dialogue between judges. Because at the end of the day, to have a so complex legal order as the legal order of the Union working, you need the communication, the permanent communication and understanding of all the authorities from the executive side, but also from the judicial side in the Union, especially when you have, simply think, we have to think a little bit about some stupid element, which is language. So language makes a big difference between Romania, Bulgaria, France, Germany, Italy. So are we sure that all the professionals of law are able to express themselves, for example, in English? No, it's not the case. That is a very basic fact in the legal universe of the Union. So I was coming back to the referral for preliminary ruling. And then a good development in the last year is that we have had for the first time preliminary rulings referral for preliminary ruling comments from the Constitutional Court, which was very, very rare before. And it's precisely this is the constitutional order who has sporadically come into conflict with the Court of Justice. It's a curious thing. I think it's a paradoxic thing. It's important to note also that now, in fact, none of these constitutional court that enter into conflict with the European Court of Justice has questioned the principle of primacy itself. As it's defined in Declaration 17, that was exactly the same definition that was in the Constitutional Treaty. Is and I remind that is the text of 17 is the conference recalls that in accordance with the well-settled case law of the Court of Justice of the European Union, the treaties and the law adopted by the Union on the basis of the treaties have primacy over the law of member states. So it's a definition inside the competence of the European Union. Primacy works inside the competencies attributed to, and this is, in my opinion, the real problem of all these things. So the conflicts between the constitutional order and the Court of Justice have happened in two periods of time. We have a first range of decisions in the 70s, 80s, before Maastricht. That is really a border, a frontier. So we have there the controllimiti case law, the Italian one, the Solang 1 and Solang 2. And in all these cases, the problem was the fundamental rights and the constitutional identity. Even the Italian court spoke about inalienable rights of the human person, so even more restricted than the fundamental rights in general. And they didn't oppose really the Court of Justice. It was kind of condition. If they were the definer, or it was a kind of threat. If that happened, we will say that. So it was a confrontation or not, so more intellectual than another thing. And it's comprehensible, in my opinion, because we are in a period in which union law was a long reach and didn't exist any consideration directly in the treaty about fundamental rights, about democracy, about anything. And even the parliament at that time has simply no competence at all. So it's even comprehensible that the reaction of those constitutional courts. Then we have another period of rebellions, let's say, I simplify. That is these last 10 years after the Lisbon Treaty. And that, in my opinion, is has more consequence than the first cases. I will mention only the two by the Bundesverfassungsgericht, the Gauweiler case and the Public Sector Purchase Program case, the PSPP case. Especially the second one, because the Gauweiler, the German court avoided the confrontation with the Court of Justice with an interpretation, a constructive interpretation of the rule. But in the second one, the confrontation existed. And in fact, declaring ultra-virus the doctrine of the Court of Justice and the decision of the central bank who was behind. And in this decision of the German court, the question that was underlying was the one who has the competence to define competence. I have the answer. I have a very straightforward answer. The Court of Justice has the monopoly of the interpretation of union law, so is the one who will say if a certain directive is in the context, appears in the context of the competence of the union or not. But that does not seem to be so clear for some constitutional jurisdiction starting with the German one. Which even goes so far as to make a judgment of intention against its colleagues in Luxembourg, assuming that they will always act in the interest of maintaining or increasing the competence of the union, since that increases the legitimate scope of action. So that is one of the comments that shocked me the more when we read this the decision of the Bundesverfassungsgericht. But similar questions of powers have arisen before other constitutional jurisdiction in Europe in this period. I will not mention even the direct confrontation by the Polish or Hungarian courts, because there is a political problem behind. So probably they cannot be compared with what is the position of the German court. Or the German court is particularly relevant because we all know the influence this court has in the doctrine of other countries. And all the courts that really have pronounced themselves in a strong way are courts of is the Italian, the French, now also the Danish, all founders countries, and some of them more of the populist countries of the Union. So there is a political relevance that is not only legal in all those pronunciations. Then I'm coming back to the question of competencies. To the connection between the principle of primacy and the distribution of powers. And I would like to refer to a ruling of a constitutional court, this time the Spanish Constitutional Court, in 2004, in which it affirmed the compatibility of the constitutional treaty with the Spanish Constitution. In that decision, the court made a differentiation between the supremacy of one legal system over another and the primacy. In the first case, we will be dealing with a hierarchical relationship, vertical. In the second, with a relationship of separation of competencies, a separation between the different areas of application of the rules. Then, so it's an horizontal relation then. It actually describes the relationship between the different levels of power in a federal structure, such in the Spanish case or the German one. The different levels of political power are not in a hierarchical relationship, but rather a horizontal one of separation of the areas in which they exercise their mission. With the exception precisely of the Constitutional Court, whose jurisdiction governs all levels of power. And that is, I think, very, very relevant for the question, for the European question. And it can be perfectly applied to the Union. So the only fragility for me of the principle of primacy of union law is entirely linked to the distribution of competence, which is particularly complicated at the level of the Union. It's worth remembering, for example, the mechanism which presides the exercise of the shared competence. The shared competence, the Union's competence is extended à fur et à mesure its exercise, but it's elastic, let's say. But can be reduced also in the event of a repeal of legislation, as Declaration 18 annexed to the treaty recalls. So this competence is never clear, it's never fixed. So that is only an example about the complexity. But all this exercise or not exercise of competence is also governed by the strict principles of subsidiarity, proportionality, the existence of an enabled clause in the treaty, a legal basis. All of them, all those principles with a degree of subjectivity that at the end of the day has to be touched by a court. And in fact, it was what happened in the PSPP case, in which the German court said that the European court was not applying proportionality correctly. Okay, so the principle of primacy, when it was introduced in the draft constitutional treaty, I have to remember that because it's very curious. It was very easy. So it was in the context of competencies working group. It was a recommendation of those working group that was chaired by a not really a federalist one. It was Henning Christophersen who presided this group. I was in charge of it, so I leave it very directly. And it was not difficult at all to introduce in the Constitution this principle of primacy. It was very easy because it was why? Because it was limited to the case law. So inside I will say within the competencies of the Union, primacy without and this is very easy. And with the same ease, it passed to the constitutional treaty adopted by the Intergovernmental Conference and then so destroyed by the referendum, so by the people who vote, dear Sacha, in the Netherlands and in France. And so it was introduced in this declaration just to say, because in fact the whole thing was done at droit constant. So the introduction in the constitution was so easy because it was at droit constant, is in any case a confirmed case law of the Court of Justice, so nothing changed. And so to say the fact that we take it out doesn't change anything, so we need a declaration with the comment of the legal service of the council, who is added there. So I am of the opinion, really, to conclude, I am of the opinion that we need this clause in the treaty, but we need this clause not as it was in the constitutional treaty or in the declaration. We need that to reaffirm the competence of the Court of Justice, the power of the Court of Justice to deal with the competence problem. So to deal with, to affirm that it is competent to decide when the union exercises in his competence in a legitimate way. So that you were calling, Sacha, maybe I don't agree completely with you, supremacy, I will call that simply primacy. But I mean, in this division, the Court of Justice has need a status of constitutional court that can decide for the whole level, for all the levels of political power. Okay, so that is my conclusion. Thank you very much. It's a pleasure to discuss with both of you, Amedeo and Micaela. Thank you.
Thank you, Maria José. We could feel that you were passionate and involved about the topic. I saw Sacha nodding several times. And would you like to intervene and make comment immediately before I give the floor to Rafał? Or
No, let's hear from Rafał. I mean,
okay, very good. So last but not least, I have here with me my colleague Rafał from the research service, who has been writing a lot about some landmark rulings last year and the previous year. So I will give the floor one of the other. The ruling was not only Costa Enel, but also Costa and Sacha. And please, Rafał, the floor is yours.
Yes. So here is my briefing of about this Da Costa and Sacha, and my presentation is based on this. So following these excellent presentations, which focused on the Costa Enel case and the later development of the principle of primacy in EU law, and my brief intervention closing this panel, I would like to go back where we started, so to the history of European law once again, and focus on the conceptual links between Costa Enel on one hand and the two cases decided the year before in 1963. So the well-known and celebrated, which was already mentioned here, Van Gent and Loos ruling of 5 February of 63 on one hand, and the much less discussed and certainly not celebrated, there are never any academies at the European Court of Justice to celebrate it, the case of Da Costa and Sacha, decided on 27 March, also 63, so 6 weeks later. Now, interestingly, both the Van Gent and Loos and the Da Costa and Sacha cases were concerned with exactly the same legal question submitted by the same Dutch tribunal, the Tariefcommissie, so an administrative tribunal competent for customs cases. And as we know, the Tariefcommissie wanted to know whether Article 12 of the Treaty of Rome, which contained the standstill clause on new tariffs, has direct effect before national courts. And as we know, in Van Gent and Loos, the court decided in favor of the direct effect doctrine, which at the time, as Sacha already mentioned, existed in Dutch constitutional law. It was enshrined through constitutional amendments of the 1950s, although it was not known explicitly in other member states at the time, and some of them, as we know from the submissions of the governments in the Van Gent case, some of them actually rejected this doctrine because of dualism and supremacy of the national constitution. Already at that point, so in Van Gent and Los, the court described very famously the community as, I quote, a new legal order of international law for the benefit of which the states have limited their sovereign rights, and highlighted that individuals are subjects of that legal order. So not only the states, but also the individuals. I refer here to the title of our today's seminar about the role of individuals in building and developing European law, and upon the subjects, the European law confers rights which become part of their legal heritage. So said the court. But at that stage in 63, the court did not make an explicit reference to primacy. In logical terms, we could say that primacy is implicit in direct effect. Primacy in this understanding of precedence, of course, because if the national court in Van Gent is instructed to give precedence to the clause of Article 12, standstill clause, then for all practical purposes, it will have to set aside the later Dutch legislation introducing a different tariff classification for this formaldehyde product, which was at stake. So in Nutze, we could say, in Nutze, the doctrine of primacy was already present in the doctrine of direct effect, in a sense. But given the absence of a clear indication of direct effect or primacy in the text of the Treaty of Rome, and the prevailing views of most of scholars of public international law and of member states' governments, legal advisors at that time, which were not favorable to those new doctrines, as we know, it turns out that in formal terms, these new doctrines were founded on what? On the assumption that the European Court of Justice enjoys authority to interpret community law, and that such interpretations are binding not only in a single case, as many lawyers at that time argued, so not only inter partes, but also generally, erga omnes. In fact, just like the doctrines of direct effect or primacy, so too the binding nature of ECJ case law obviously was not codified in the treaty itself. Also, the views of legal scholars were quite far at that moment from such a view. Continental Europe, belonging to the civil law family, was opposed strictly to the common law family, and the concept of binding precedent was treated as something confined to the common law world, so on the other side of the channel. But the European Court took the earliest opportunity to clarify this issue and to declare that the legal interpretation contained in its judgment should be considered as generally binding beyond the mere case in which it was pronounced. This opportunity came very quickly after Van Gent and Los, because the same Dutch tribunal, the Tariefcommissie, submitted a few weeks later 3 more questions. And these 3 questions were treated as joint case, Da Costa and Schake by the court, which was proceeded separately, going after, chronologically, the Van Gent and Los. So first we have the judgment in Van Gent and Los, and then what to do with these 3 cases. There were 3 options on the table. Firstly, as the Commission proposed, to reject these requests, because the answer is already given. Reject and say nothing. Just to reject is inadmissible because this is what the Commission wanted. Secondly, to answer them and provide the same answer, because the legal point is the same, we just say the same thing. And this is what Advocate General Maurice Lagrange suggested. And thirdly, we'll answer the 3 requests, but redirect the National Court to the Van Gent ruling as authoritative. And this is precisely what the court said. The choice of the court of action ultimately depended on the legal force of the Van Gent ruling, outside the scope of the case in which it was pronounced, so erga omnes. Advocate General Maurice Lagrange believed that the binding effect, and this is a quotation from the opinion, he says to the judges, the binding effect of your judgment of 5 February, so in the Van Gent case, does not extend to the 3 other cases which are the subject of separate requests by the Tariefcommissie, on which you have not yet given judgment. So he takes a very strict inter partes understanding of the authority. He says, no, this is a new case, this is a new parties. Even if the legal question is the same, this is a different case. In fact, Advocate General Lagrange was very concerned not to adopt any system of binding precedent. I quote again from his opinion: "The Court of Justice should, in this as in all other matters, remain free when giving its future judgment." So he's afraid of the doctrine of binding precedent in the Anglo-American and the classical English sense, that the court becomes bound by its own precedent. However important the judgment which it is led to give on some point may be, whatever may be the abstract character which the interpretation of some provision of the treaty may present or appear to present, the golden rule of res judicata should be preserved. It is from the moral authority of its decisions, and not from the legal authority of res judicata, that a jurisdiction like ours should derive its force. End of quote. The Advocate General went on to consider the possible distinction between the binding force of ECJ judgments upon the ECJ itself, which he vehemently rejected, and its binding force on national courts, which he likewise rejected, arguing that the legal force of community law is a matter to be determined by the legal systems of the member state on the level of national law. This actually echoed the view of Advocate General Römer in the Van Gent and Loos case. Concluding his opinion, Advocate General Lagrange advised the court to answer the Tarif Committee once again, giving it exactly the same answer as 6 weeks before, but without making any reference to Van Gent and Loos, to avoid any idea of binding precedent. Well, just like in Van Gent and Loos, the judges did not follow this time also the Advocate General opinion. Instead of repeating the same answer, they replied to the National Court that there was, I quote, no ground for giving a new interpretation of Article 12, unquote. In the motives of the judgment, the court explicitly recalled the Van Gent and Loos case, quoted the operative part of its ruling, and added that, I quote, the interpretation of Article 12 of the EEC Treaty, which is here requested, was given in the court's judgment of 5 February 63. The questions of interpretation posed in this case are identical with those settled as above, and no new factor has been presented to the court. In these circumstances, the Tarif Committee must be referred to the previous judgment. The statement that the interpretation was already given, read jointly with the statement that there is no ground for giving a new interpretation, and that the Dutch tribunal must be referred to the previous judgment, constitutes the juridical essence of the Da Costa ruling. As José Ramón Bengoechea remarked, the real significance of the Da Costa ruling is the assertion of the authority of the ECJ's jurisprudence. The ruling in Da Costa advanced for the first time the doctrine that the ECJ's judgment is binding, so the juridical content of the judgment is binding not only on the national court which referred the question, so inter partes, as the Advocate General would have had it, but that its authority is universal, erga omnes. In this way, the decision in Van Gent and Loos was presented as legal authority, upon which the Dutch tribunal may rely in order to ascertain the correct interpretation of the treaty. Today, the jurisprudence of the Court of Justice is, for all practical purposes, an essential element of the Union legal order. This is obvious. But this would not have been possible if the court had not, already back in 1963, asserted its legal authority. In this sense, the judgment in Da Costa and Sacha can be seen as being just as important as the two more famous cases of the same period, that is, Van Gent and Loos and Costa Enel, that we discussed today. Thank you very much for your attention.
Thank you, Rafał. Now, I have a couple of questions. I see there is no yet, so I can probably go back also to the intervention to Sacha, the way forward. So we discussed about the possibility to have this principle of primacy in the EU law, primary EU law. That was in one of the 2 years ago resolution of the European Parliament, a resolution by the AFO, Constitutional Affairs Committee, and the URI Committee, Legal Affairs Committee, the idea, and if I remember correctly, the wording was to mitigate exactly possible conflict between the national legal orders and EU legal orders. But I heard also the intervention of Sacha, in which you say that it would be required a sort of we the people, meaning what could be done. Now, remember what happened with EU constitution and the risk that any referendum would entail. What would you be, according to you, a possible way forward, or is realistic, or is it ideal to integrate the EU primacy law in principle in the primary law? Professor Arena, would you like?
I'm afraid the connection is not exactly the best, so I might have missed some of your questions. Could you kindly repeat them?
All right, I can. It's what is the possible way forward for the principle of primary EU law, either in a EU constitution. You can hear it. Sacha, would you like to intervene, sir?
Thank you. Yes, the connection seems to be a little bit shaky, but I think I understood your question. By the way, I just want to congratulate all the speakers. I already congratulated Amedeo, but María José and Rafał, I mean, that those were two amazing and thought-provoking and stimulating and enriching contributions. So I'm very, very happy to be part of this, I have to say. Okay, so your question, which is of course a very tricky one. I do believe that we need public deliberation on this question. If we were to take primacy only as precedence and almost in a kind of, pacta sunt servanda, really effectiveness interpretation, then we might not. But then I find it hard in view of constitutional theory, in view of the sort of logical chains of legitimacy, to deny national constitutional courts their control limiti doctrines. If we want to overcome those doctrines, then we have to overcome conferral, and we have to overcome the confederal basis of this construction, and we need instead to have a constitutional basis in which the people directly decide on the system of governance in which they live, and the authority that they exercise ultimately in a democracy, right? That is the essence of democracy. So then, yes, then we need a constitution. So in a way, I guess I first want to say that as a first step, we need to deliberate this. This needs to be something that we discuss with the citizens. The different iterations of this authority construction. What are the different versions of primacy, of precedence, of supremacy? What does it mean for the national constitution? What does it mean for the European Union and its powers and competences, etc.? Right? I agree that it's problematic, because meaningful deliberation depends on a healthy public space and on a healthy democratic system. And I have very deep worries about the state of democracy, not just in a couple of our member states, but in all of our member states and beyond. So I understand that this is a conundrum, but I don't necessarily see either that because of democratic deficiencies, we should no longer seek to ultimately have democratic validation of the central question that pertains to a democracy, namely, in what system of authority do I live as a citizen, right? I understand these are hard propositions, and I don't have perfect solutions. I just think that we need to open the box almost, if you understand what I mean. Now, as a sidebar, because of indeed, so this intrinsic connection to competences, as was expertly outlined before, I think what we are seeing is the Court of Justice also, in the face of all of these developments, changing its stance. We have seen in Eurobox, the court has changed its foundational doctrine, right? It no longer says, as it said in opinion 191, that the member states have limited their sovereign powers in limited fields to ever wider fields. It's now, since Eurobox, the field defined by the treaties. Oh, okay, take note. That is quite relevant. So there's a mutation going on. And this is crucial. This is a space to watch. And if you want my prediction, this is a prediction I've been making now for a year and a half to my students. The court is going to do another tobacco advertisement. There's going to be another directive that is going to fall to show that we take the principle of conferral seriously so that we might face less contestation on primacy. What directive do I think is going to fall? The minimum wage directive. And I've been saying this now for a year and a half, and we saw the opinion of the Advocate General come out 2 weeks ago, advising to completely annul the directive on the basis of lack of competence. I would really not like to see this happen, because I think the minimum wage, so first of all, disclaimer, I like social Europe. I dabble also in EU social law. So a tentpole achievement of social Europe, the minimum wage directive, I don't like to see go. I admit that the legal basis that was chosen is somewhat uncomfortable. There have been quite a few uncomfortable legal bases in the history of the European integration process, and except for tobacco, they all passed, right? So to now then have a milestone of social Europe in the face of still, I think, an asymmetry between the economic and the social in the EU construct would be tragic to me. And at a more fundamental level, I would find it tragic that what for me is one of the least problematic types of EU authority, namely legislation adopted under the OLP post-Lisbon, with the Parliament as co-decider, with the national parliaments as via the early warning system involved, with QMV, just a beautiful achievement of transnational democracy, to see that space curbed. Whereas there are plenty of other types of more questionable EU authority that would remain standing, such as acts like, I don't know, former second, third pillar acts like the European arrest warrant, which is very dubious from a constitutional human rights and democratic perspective, but which the court has been going at lengths, inventing mutual trust as a constitutional identity that prevents us from acceding to the ECHR in order to save the effectiveness of these acts of Dublin. And anyway, so please, court, don't annul the minimum wage directive. Find another sacrifice, sacrificial victim to take conferral seriously. Don't kill social Europe to preserve primacy.
Thank you, Sacha. Amedeo, are you?
Yes, I'm back online. No, Sacha raised an excellent point, as did María José, linking primacy to the world of competency, subsidiarity, proportionality, and conferral. Well, in this respect, maybe there is something else that is missing, not only primacy in the treaties, but maybe there's something else that is missing in the case of the Court of Justice, a European doctrine of preemption. So primacy, well, tells us that in case of conflict, EU law prevails on national law, but in case of conflict. So primacy, preemption should tell us when these conflicts arise. And the very notion of conflict, which can be narrow, can be broad, really determines the locus of sovereignty. So Sacha is absolutely right. Well, she's written extensively on this, that the competence catalog will sometimes obfuscates rather than illuminates the competence issue. Well, I think if the Court of Justice were to develop a doctrine of preemption, tells us, when exactly a certain provision of EU law conflicts with national law, it would be maybe take a bit pressure off the principle of primacy. So the national instances for further regulatory autonomy, they could be framed as preemption arguments, as they are in, for example, the American federal system, and rather than challenges on the principle of preemption or primacy. And maybe this will make things clearer. And also, thanks a lot to Rafał for pointing out the Costa ruling, which is definitely a leading case that didn't make it to the status of leading case. There is this Latin word, habent sua fata libelli, books have their own destiny. So for some reason, some cases become famous and some don't. Take Costa, for example, is considered as the first expression of the principle of primacy. But in Hamblé in 1960, well, the court expressly said that community law took precedence, the treaty took precedence over national law, although the context was quite different. So it would be really interesting to look deeper into the Costa ruling and understand why it didn't make it to the status of leading case, even though it is absolutely essential for the construction of the European legal order. And finally, was primacy implied in Van Hende in direct effect? Well, probably was, but I'm with Judge Ezio Perillo on this. So Van Hende, according to historiography, was decided by a very narrow margin. So apparently the President of the Court, Donner, was against direct effect. So was the Judge Rapporteur, and of course, so was the Advocate General. So in normal case, we would say this is a no-brainer. The outcome will be no direct effect. And instead, we know that Judge Alberto Trabucchi, the Italian judge, backed by Robert Lecour, also the new French judge of the court, they managed to swing the vote in the other direction. And possibly the cost of doing that was reversing the perspective on the effects of community law. So rather than from a top-down perspective, the one that was advocated by the legal service of the European executives, Michel Gaudet, the idea that the effects of the treaty should be defined in the national legal orders should be defined by the treaty itself, and therefore primacy and direct effect should be linked. Instead, Trabucchi insisted, and so to go back to the theme of today's webinar, on the role of individuals. So he took a bottom-up perspective. And so he said that this case is not really about the direct effect of Article 12. It's about the legal protection we want to give to individuals, even against their states. Do we want an international law style of protection where individuals are defenseless vis-a-vis their states and can only hope for other states to react? Or do we want to create something new? Well, we know what solution the court chose, and to be honest, I'm quite happy the court adopted that decision, and so paved the way to the Costa ruling, which, according to historiography, either was a 7-0 decision or the issue wasn't really controversial in the deliberate. Thanks.
Maria José, would you like to add something?
A little thing. I always in admiration of how Europe functions. It's so complex. It's so difficult. It's to think about Roman law and multiply that for I don't know how much, and the effect on homogenization, because we are speaking about decision of 64, but from that time to today, the homogenization of all legal orders, national legal orders, affected by the law of the Union is impressive. I mean, my point is, at the end of the day, is that eppur si muove. The sentence is eppur si muove. It works. Sometimes trying to do the best, we achieve the worst. So I'm more, from my experience of so many years that I am in pension now, from my experience, reform and progress, little by little, is more efficient than doing it. And that works at the level of the union. I mean, I think I can speak about moments of rupture and foundationals, like the constitution and so. But at the end of the day, you will say, Sacha, the people has to debate and intervene. If we have got that constitution, I mean, the constitution is in the Treaty of Lisbon. The Treaty of Lisbon is 97% the constitution. It's the constitution without all the constitutional images, without the flag, without the anthem, without the primacy of law, but at the same level of law, the same development, so law constant, etc. But it's not the same. I know perfectly well. So it's, I mean, legislative procedure, legislative acts, delegated acts, the whole thing is not the same in the context that the Constitution put in, even if everything is in the Lisbon Treaty. So I agree that there is a difference, but there is a progress. So if you compare what we can do today with what we did in 2003, and is a world of difference. Oh? And there was not new competencies with the Lisbon Treaty, not new, nearly nothing new, because even the things that were new, like space, for example, the policy of space, so go to the moon. It was not new. It was something that was considered in the flexibility clause. So, I mean, I think that we should go ahead with what we have. And there is a lot of things that have been not done under Lisbon. And if there is the opportunity, if the opportunity opens for a nice constitution, for a foundational moment, for a discussion with citizens of the union, but I have the impression that we are not there, And we are not there, among other things, because we are thinking very seriously about very daring enlargement of the union, because we are thinking about other things. So in the meantime, it's true that the law progress, the order of the European Union, the legal order progress through legislation that, I'm sorry, but academia very often forget about, and also the activity of the Court of Justice. Okay, so, I mean, let's be pragmatic, let's be positive, let's be constructive. So I answer like the conservative that an old woman should be, okay?
Thank you, Maria José. We have 3 minutes left, but I have a question in the chat, if I can read it quickly. It's from Maria Diaz-Grego. It's about the relation between constitutional courts and the ECJ. My impression is that the ECJ is going further and further in undermining the role played by national constitutional courts in their own national legal orders. And as an example, we could probably mention the Meloni case on the interpretation of Article 53. In which ECJ indicated that ordinary judges do not have to abide or follow a ruling of their constitutional court if it's contrary to EU law. Sacha, see you nodding. Would you like?
Yes. No, indeed, I wanted to just come to that question that I saw in the chat. I think that is an argument made. So the question asker can be referred to the work of Jan Komarek, for instance, who has written about this under the label of upsetting national judicial hierarchies, and to explain in a way where some of the most profound contestation comes from that perspective of the empowerment of lower judges, which of course this case law has engendered, which has for a long time been, and by Weiler, for instance, Transformation of Europe, been identified as the main sort of motor of success, which is partially true, but which also then, of course, planted some seeds for discontent in the highest national judiciaries, who could be betrayed or undercut or destabilized by their lower colleagues. So that is a very interesting perspective, and indeed I refer to those writings for further insights on that.
I look at María José and Amedeo, unless they have no further comment. Rafał. Well, you proved that EU law is not boring. Much on the contrary, it's an interesting and fascinating topic. I invite anybody else to read your publication and an article, and you follow your discussion. That was very lively, and I would like to thank you. And with this, we end, and have a nice afternoon. Thank you, everybody.